living?
I am a broadcaster.
Um, could you be more specific?
I do a internet talk show.
Would you consider yourself to be a journalist?
I would say talk show host is more accurate.
So you would consider yourself to be in the profession of informing the public? Is that what you would consider yourself to be?
Objection, Your Honor. Asked and answered.
Overruled.
I would consider myself in the entertainment business.
What would you consider Mr. Rekieta to be?
Well, that's a little more complicated. He's an attorney who also streams.
Would you consider him to also be a broadcaster?
Part-time.
When did you first meet Mr. Rekieta?
October of 2023.
And what was the context of your meeting Mr. Rekieta?
It was a comedy show that I had put on, a stand-up comedy concert show.
Where?
Sartell, Minnesota.
And was Mr. Rekieta a participant or a guest?
Both. We had him do what's called a guest set, which is he was there and we asked him to do some time.
Doing what specifically?
He attempted to do stand-up comedy for the first time.
Do you think he was unsuccessful at stand-up comedy?
Objection, relevance.
It speaks to the relationship.
Since we're just starting out, I'll give you a little leeway. Overruled.
It wouldn't be something that should be his profession, I would say.
You talked about the relationship deteriorating. When did the relationship deteriorate?
April of 2024.
Do you have a specific date?
I believe on or around April 11th.
You also testified to having had communications with law enforcement regarding Mr. Rekieta?
Yes.
Were those communications before or after the deterioration of your relationship?
Just slightly after the deterioration of our relationship.
So was it before or after the point that you described Mr. Rekieta being arrested?
Mr. Rekieta was arrested before I was contacted by law enforcement.
So it's your testimony that you had no contact with law enforcement regarding Mr. Rekieta prior to him being arrested?
No, I was called by Detective Quinn Pomplin after the arrest.
Who's April?
April is my ex-wife.
What is Mr. Rekieta's relationship with April?
We were all friends, and I would say it was a complicated relationship.
Did the complications in the relationship contribute to the deterioration of your relationship with Mr. Rekieta?
Well, naturally, I think any relationship that falls apart, it's the nature of the relationship that tends to cause it.
You testified earlier that you believe that Mr. Rekieta had accessed your Google account.
Yes,
How do you know that?
because of one of the exhibits that was shown here where he tweeted out a screenshot he had gathered of my Google browser history.
And how do you know that that screenshot was made by Mr. Rekieta?
I was able to recreate it on my own Google account, on my own browser history, beat for beat.
That's not the question that I asked you. I asked you, how do you know he's the one that made that screenshot?
Because it was made by his Twitter account that he is in control of. And there is also a video where he talks with Patrick Melton about accessing my Google accounts. And Patrick Melton has even claimed that Nick Rekieta sent him.
Objection, hearsay.
All right, Mr. Johnson, do you have anything to connect them together that would make that admissible?
Your Honor, I mean, this testimony has already been covered. There was no objections regarding indirect testimony. I mean, the defense counsel had, or excuse me, opposing counsel had an opportunity to object to these claims, and the court admitted them without sufficient objection. And so I believe that these questions are just repetitive of evidence that's already been accepted by the court.
All right. So it seems like we're getting at whether or not the Google account was hacked or observed or opened up at some point after deterioration of a relationship. Plaintiff has already put in evidence that Mr. Rekieta took, or at least his ex handle posted something related to that, wherever it may have came from. I will tell the parties I don't know how much of a difference that makes to me, but if there's additional questions on this topic, Mr. White, please feel free.
The objection, Your Honor, was related solely to what Mr. Melton was alleged to have said.
With him not here, well, he's here, but not. I'm not going to take into consideration whether or not Mr. Melton told somebody else that Mr. Rekieta did something. It's whether or not Mr. Rekieta did it or not. And unless Mr. Melton's called, it's not going to go into my findings.
Thank you,
That
Your
portion
Honor.
of the objection is sustained for the record. Go ahead.
Thank you, Your Honor. Is Mr. Rekieta the only person who could possibly have looked at your internet history?
Objection calls for speculation.
Did other people have access to your internet history?
Not outside of myself, no.
And on that ground, Mr. White, you could follow up.
Did you have a computer in your home?
Yes.
Did anybody else use that computer?
No, just me.
Your former spouse never used that computer?
Before she left, that computer was what we used for work and everything else. I used that to run the show. So no, she would use her own devices in terms of internet usage and things like that. She had a laptop. Those were not logged into my Google account. Her devices were not logged into my Google account.
So are you testifying that she never used that computer?
To my knowledge, that computer was used for streaming purposes. A lot of my Google browser being done on my phone, a Google account tracks where your Google account is logged into. My Google account was not logged into her personal devices.
So if there was testimony or evidence to state that on April 1st of 2024, your former spouse, April, used your computer to perform your show solo, she would be lying?
I don't believe she would have been using the computer. I believe I would have been the one who set up the stream for her. She did not know how to set up streams.
That's not the question that I asked, Mr. Imholt. The question that I asked was, if on April 1st of 2024, she did a solo show where you were not there.
Yes, she did a solo show from that computer, yes.
So she did have access to your computer.
To the when she was using it in the studio, yes.
So there is a possibility that someone other than Mr. Rekieta made the screenshot that you're so concerned about.
Highly unlikely, as Mr. Rekieta was the one who posted said screenshot.
You're assuming something that's not in evidence. It was posted, as the judge said, from his Twitter account. But that doesn't mean that it was him.
He is the one who disseminated the information from my Google account.
How do you know?
Because it was on, again, we're going in circles. It was on his Twitter account. It was posted by him.
You do not know for certain, do you?
Who's this guy, this
that
soft weekly guy?
Somebody using that Twitter handle had to have been Mr. Rekieta, do you?
I reasonably assume that Mr. Rekieta is in control of his Twitter account.
Have you ever left your phone open and so that someone could actually pick up your phone and use it? Have you ever done that?
I've never had anyone use my phone to post something from my Twitter that wasn't me.
That you know about?
All right, counsel, enough. Move on.
One of the objections that you made, claiming that you were being harassed and stalked by Mr. Rekieta, was an objection that he showed up at a hearing that was held in Stearns County Court. I believe it was on the 26th of June. It might have been the 25th. I'm not certain of the date. What was that hearing for?
That was for the dissemination case that I'm currently involved in.
Your Honor, I'm going to object to relevance. That case has nothing to do with the HRO matter at hand.
Actually, Your Honor, may I?
You may.
It does. It has relevance because the victim in that case is Mr. Rekieta's wife.
Your Honor, again, I would object because Mr. Rekieta's wife is not a party to these proceedings, and we are solely focused on the harassment allegations made by my client, and that should be the scope of the cross-examination.
And so Mr. White is the defense that Mr. Rekieta, if he did anything, has an excuse because he's upset, or are you simply trying to elicit that Mr. Rekieta had another reason to be there, which is concern for his wife?
I am eliciting that his presence at the hearing was because his wife was the victim in that case.
Okay, so let me ask that limited question, which gets your point across. Mr. Humboldt, is the person you were charged of dissemination case, is that Mr. Rekieta's wife?
Yes, Your Honor.
Okay. And is it fair to say then that Mr. Rekieta may have had an interest in the case that was related to her as well?
I believe both, yes, as well, along with the.
I understand the competing arguments about what happened there. And I understand also the impetus as to why Mr. Rekieta may have been upset about and want to monitor what had happened in that case. Mr. White, with that, I think you've made your point. If there's anything additional, if you'd narrowly tailor it.
No, Your Honor, that is all that is necessary. Mr. Imholt, you talked at length about something that took place in Las Vegas, Nevada, and attempted to present a video of that. Do you remember that?
Yes, sir.
What is that event?
It is called Hackamania. It is an event that Patrick Melton puts on. The majority of the content is geared towards mockery, humiliation of myself.
So there was 3 days of mockery and humiliation of you. Is that your testimony?
Yeah, that's pretty wild, I would say.
Did you
Yes.
participate?
Is that a yes or a no?
Yes, yes, sir.
Did you participate in that event?
I was asked by a co-host of a different show to make a video package for his program that he would be doing there. He pitched it as me being the heel and doing a little roast segment. Had I known, if I would have been told that pictures of me and messages from me would be disseminated, I would have not recorded that for him. I recorded the package, sent it to him, and he used it how he wanted to use it.
Did you ever post a picture of yourself without your shirt on?
With my own permission, I believe possibly at the gym or something like that. I can't be sure. I can't think of a specific instance where I've done it.
Let's take a look.
The bedroom photo that was sent, I have never released publicly, and I never gave consent to release it publicly.
I didn't ask you a question.
Mr. White, oh, there we go. Mr. Raketta's video is back on. We're good.
Hmm.
It was
Oh,
briefly off. It's on now.
Okay. It's not here. Did you share it? See. We're attempting to share some impeachment evidence, Your Honor. Oh, okay. That's still processing. You testified that Mr. Arcata showed up at a gym shortly after your hearing in June. Is that correct?
It could have been before, it could have been after. I just know it was posted after.
Were you at the gym?
No,
Could you have been at the gym?
depends on when they went. If they went before the hearing, then yes, I could have been at the gym.
You testified that your basis of knowledge on that is video evidence that you
Yes.
saw.
Yeah.
Can you tell me which one of your exhibits that is?
I don't know which exhibit that would be. With that, it is not one of our exhibits.
So the basis of your knowledge is video exhibits which are not in evidence. Is that correct?
Correct, but the admission that they went has been in numerous videos before and since that they went on this little field trip. I believe one of them is the June 25th stream from Patrick Melton, where they discuss going to all of these places.
Is that in evidence?
Yes.
Just to clarify, I don't believe a June 25th stream
Oh, I'm
is.
sorry, that's for the Patrick Melton case.
So there is no evidence in this case that anybody admitted to being there.
Your Honor, I believe that the videos were provided in this case as well. The exhibit would be, let's see, exhibit number number 13. Let's see. Your Honor, this exhibit would be exhibit 15.
Okay. Exhibit 15 means potentially multiple things here. Is that in this file?
Yeah, yes, it should have been uploaded to this file.
Okay.
Yes,
It's your listed exhibit 15, a June 26, 2025 live stream post. Is that correct?
Correct, Your Honor. It is
A 5-minute and 59-second segment is listed on the.
excuse me, it's June 26th of 25, and the total video time is 22 minutes and 13 seconds.
Okay. And the. Okay, I see that here. I haven't obviously watched it. It's not yet in evidence. So
Reserved for impeachment purposes, Your Honor.
yeah, of course. And it's also Mr. White, if he says it is and you say it's not in evidence, then he'll come back and.
It is. This video is in evidence, Your Honor. I mean, this video is in MDES.
Right. So you've got it. You're asking him about the video. He says it's in the video. Are you planning to make him put it in rebuttal or tried off in rebuttal?
Yes, Your Honor. I'm planning to make him put it in and do a rebuttal.
Okay.
If it's going to show what he purports it to show. But I'm also going to do a complete disobjection to it because, again, it is not the whole video. I understand your position.
Just so I understand your argument, so we can maybe speed up the hearing a little bit. You're crossing him about whether or not he put in any proof. You know there might be proof. You say the proof isn't complete enough, and you're crossing him on the nature of what he hasn't yet put into evidence.
That is, but anticipating that he will. Okay, so.
Your Honor, I object to that. You can't question with anticipation.
Yeah, you're. It's also not effective. You're attempting to impeach him by the fact that there's no video evidence. Yet you acknowledge that there's video evidence, and the goal is that I don't allow it in because it's not complete, even though you're talking about a small portion of it. So I'm going to let Mr. Johnson try and prove up that foundation for that, so we don't lose track here, and then we can talk about what isn't complete, and you can cross-examine him if you want. Go ahead, Mr. Johnson.
Your Honor, at this time, respectfully, I would prefer to reserve it for potential impeachment rather than have it be part of our case in chief.
Fair enough. We'll just wait. All right. Go ahead, Mr. White.
Thank you, Your Honor. Do you know if Mr. Ricader ever had a membership at the gym?
The only thing I know is when he would go to the gym with me, they would pay what's called a day pass. It's $8 and it allows guests to come in and pay for a day's worth of usage.
How often did he go to the gym with you?
Objection, lack of personal knowledge.
I specifically asked how often Mr. Ricader.
Excuse me,
Mr. Imholt.
All right. We were premature objection. It's withdrawn. How often, Mr. Emholt?
I would say 2 to 4 times a month.
Thank you. Mr. White.
Okay. Throughout the course of your relationship with Mr. Ricada, did you ever tell him that what he was doing was unwanted?
Objection vague.
At what time are you referring to, Mr. White?
I'm referring to the time that is specifically related to what he is now claiming is harassment.
The post-deterioration?
Yes, the post-deterioration. So
That makes sense. All right. So around or after April of 2024, did you ever tell Mr. Ricada that you didn't like what was happening?
I did not, especially when it came to the Google release, since I reported that to law enforcement, I didn't think it would be appropriate to contact him.
did you respond to the X post that you claim you were tagged in?
Which X post are you referring to?
You submitted as an exhibit. I believe it was in May of 2025.
Because there are multiple X posts we put in as exhibits.
So May 10th of 2025 is T13. That's the because he isn't dead, comma, yet post. Is that the one you're referring to?
Yes, Your Honor, that is the one I'm referring to.
I do not know if I responded to that or not.
So you never told him this, you cannot testify that you told him to stop it.
Well, no, I'm not going to respond to someone who's vaguely threatening my death. No.
Vaguely?
I mean, that's how I interpreted it. I interpreted it as he isn't dead yet, meaning what's, I mean, it's pretty jarring to see that.
How about the signal message from the year before?
Well,
did you tell him to stop?
Well, I told him I was cutting off the relationship entirely. So yes, I was telling him that I wasn't going to be going over to his house anymore, seeing him anymore. That's why he told me that, was because I was telling him that I didn't want to be around him anymore. That was his reaction.
So his reaction to that, but did you tell him after he said that, stop?
After I told him I didn't want to hang out with him anymore, I didn't think it was necessary.
So how was Mr. Ricada to know that this conduct was allegedly harassment?
I would know that if I told someone to kill themselves, that I would be, I personally would know that I've crossed a line and that I've definitely harassed someone. I don't tell people to kill themselves.
So you were testifying you've never told anybody to kill yourself?
No, I'm saying if I had, I would definitely recognize that as over the line behavior.
After the hearing in June, did you go to Stoney's?
No.
Did you go to the gym?
What time period are we talking about? I did go to the
day
gym.
Immediately after the hearing?
No.
No. Where were you?
For an hour, I was in Stearns County Jail. I posted bail and then I went home.
And what did you do at home?
Objection relevance.
Sustained.
Your Honor, it is relevant. It's relevant because what we know Mr. Imholt to have been doing at that time would have prevented him from being
Counsel's testifying.
Yeah, Ms. Johnson, obviously I know the difference. This is not testimony or doesn't count. And I understand why you're objecting. So you say you know that he couldn't have ever known about what happened at Stoney's?
No, Your Honor, I'm saying he could not have been at Stoney's or at the bar, and Mr. Ricada would know that when Mr. Ricada went to the bar. So it is relevant as to what he was doing at that time.
Your Honor,
you've already established he went home and that he wasn't at the bar, and that Mr. Ricada theoretically could have known that he was, because he observed the hearing, went to the jail and then went to Stoney's to have lunch, or so to the extent that that limits that he was doing so with intent to harass Mr. Imholt by going there. I think you've made your point, because Mr. Imholt is admitting that he went to jail, went home, and that was it. And Mr. Ricada would have no reason to believe he was at Stoney's. So I don't believe that the fact that he was at Stoney's is going to weigh against Mr. Ricada, in the sense that the plaintiff can't argue that he was going there hoping to see or further harass Mr. Imholt. So I don't think plaintiff can argue that, because that's not the facts.
As long as the court understands that, that is exactly what I was trying to get at, Your Honor. Thank you.
Thank you, counsel.
Mr. Imholt, are you afraid of Mr. Ricada?
Yes, I am.
When did you become afraid of Mr. Ricada?
It was after the arrest, after a pattern of behavior emerged that wasn't stopping, when he
Fine. Sorry, glitch on my end.
Oh, okay. It was a pattern of behavior that clearly showed he wanted some sort of vengeance against me. The multiple references to my death. This was an accumulation of behavior over time that, once I realized it wasn't stopping, I was going to ask the court to intercede. Also, the fact that Mr. Ricada has a history of drug and alcohol abuse that is documented. I am
Objection. Your court's already ruled on this.
You asked him when and why he became afraid, and he's now outlining why. He's not going to get into the details, but his understanding of any understanding that he learned about it. I mean, he's already said it. So I'm going to overrule the objection. You can't go farther. You can tell me why that affected you.
Yes. Thank you, Your Honor. Because of that, I'm worried about erratic behavior. I'm worried about his level of wanted vengeance, and perhaps his impulse to react on that vengeance that could put myself or my family in danger.
Mr. Imholt, refresh my memory. When did he allegedly send you a message telling you to kill yourself?
That would have been in April
Of?
24.
And when specifically do you allege he sent a text message, or excuse me, made an X post that stated, because you're not dead yet?
That would be May of this year.
Specifically what date?
May 10th.
May 10th. Do you remember saying that on May 27th that you're not afraid of him? That you're not afraid of Mr. Ricada?
I'm not, in the context on my program, I'm not afraid of him in terms of he and I in a physical contest, i.e. a fight, a boxing match, things like that. The thing I'm worried about, Mr. White, is perhaps him showing up to my house unannounced, him showing up to my house when I'm not ready, alert, aware. In terms of he and I face to face, I don't think he provides a physical threat to me in a contest. I'm worried about your client acting erratically and impulsively in a way that I'm not prepared for and cannot plan for.
Mr. Imholt, you never alleged in your petition that he showed up at your house.
I'm worried he could.
Has he ever shown up at your house uninvited?
And he's been to my house multiple times.
That wasn't my question, Mr. Imholt. My
Yes,
question
he
was,
did appear at my house uninvited one time. I asked my ex-wife when she was moving some of her belongings from my garage not to allow Nick Rekieta and another person to my house, and she allowed those people to my house anyway.
how
Against
do you know that?
because she told me she did.
Objection, that's hearsay.
You asked him how he knew it, and he answered, overruled.
Okay. Your Honor, I would like to share my screen if I could.
Yeah, of course.
I have a document. It is in T46. Okay. It is nothing more than a hyperlink to a video of Mr. Imholt. It's from his show making a statement that he is not only not afraid of Mr. Rekieta, that he doesn't need to have an HRO.
Your Honor, I'm going to, counsel's testifying.
Sure. He's trying to summarize the document, which is actually a link. First of all, do you have this link, Mr. Johnson?
I have the link, Your Honor, but I mean, I don't think that's the same as getting the actual video. What has been provided is a piece of paper with a hyperlink on it. I think the question should be limited to that.
Right. I have no concern that Mr. White asked questions about what might or may not be on the YouTube, but the exhibit in front of me is a hyperlink. The hyperlink is.
Mr. Imholt, upon information and belief, has prevented the downloading of videos from his YouTube stream, and the video could not be downloaded. It is, however, live on YouTube, or at least it was a moment ago, and it shows Mr. Imholt impeaching his testimony right here. I think it's very probative, and I believe the court needs to see it, even in the context of referring to a hyperlink.
Your Honor, we don't know what's on that video. There's nothing been established that my client has actually deleted the video, that counsel's speculating. And so again, I submit to the court that the only thing we have right now is a piece of paper with a hyperlink that has no additional information regarding what that video may or may contain, whether that link even goes to a video now or in the past.
Your Honor,
Go ahead.
I'm suggesting that it's been deleted.
All right. So the exhibit you're offering is a hyperlink. That exhibit has no relevance because it only tells me what the hyperlink is. If there's another exhibit that says this, you can introduce it. Otherwise, you can ask him questions.
All right, Your Honor. Mr. Imholt, did you not admit that you would, and on May 27th, after both the event in Las Vegas and the alleged Twitter post, that you were not afraid of Mr. Rekieta and would, in fact, did not need an HRO and would kick him upside down and sideways, I'm paraphrasing, should he ever confront you?
I don't recall that.
You don't recall stating that you were not afraid of Mr. Rekieta?
I do not recall in the context you're talking about. And the up, down, and sideways, I don't recall that either.
I was paraphrasing. You testified that that Mr. Rekieta traveled to Stearns County on the day of your hearing. With Mr. Melton. How do you know that?
I know that they were meeting, this was discussed on live streams, that they were meeting at a location in Clearwater, Minnesota, and that they would be traveling together for a portion of Mr. Melton's trip to Minnesota. And also, I was in the courtroom. I was there. I also know that they traveled to multiple other places before that, the day before that, and the day of, they were traveling together.
How is that relevant?
I believe that their harassment is coordinated.
Do you have any evidence of that?
Well, aside from multiple live streams where they discuss it, Nick traveling to Las Vegas to go to an event that is geared towards harassing me, releasing photos that Mr. Melton thanked Nick Rekieta on screen for giving him. Yes, they have coordinated multiple of these events together.
Have you ever harassed anybody yourself on screen?
Objection, relevance.
Sustained.
Why did you participate in the event where you had good reason to believe you're going to be roasted?
Your Honor, we've gone over this already.
I don't think we have.
Go ahead, Mr. Imhold.
I was told by Vito Gesualdi, who hosts a different show that was not about me, if I would cut a video for him for his show. I agreed to do that for his show. I did not know. Nobody had told me that they were going to use photos of me against my permission, that they would disseminate these for profit, and that Mr. Rekieta, that your client would be releasing private messages between the two of us. Had I been told and given that context, I would have stayed as far away from that event and that particular person as possible.
So I know the cut of the video to Vito, last name starts with a G. Did that include the images and posts that you gave to Vito? Did that include the images and posts that was posted by or raised by Mr. Rekieta or Mr. Melton?
No, sir. No, Your
So
Honor.
your participation did not include a disclosure of all that for this event.
I did not take part in any. Mr. Gesualdi told me it would be for he and Dick Masterson's program and not for any program that was featuring me.
And in that, did he tell you that you would be shown topless or
No.
other photos? Okay,
No,
got
Your
it.
Honor. I was never told.
I had confusion on that point. Mr. White, if you want to follow up based on my questions.
I want to ask him other questions about Hackamania here. So are you saying that that Hackamania bothers you? The events that transpired at Hackamania, are you saying that they bothered you, Mr. Imhold?
Yes, I would say having my photos disseminated, yeah, that bothered me greatly. It was a violation of my privacy.
Then answer me this. Why did you say days after Hackamania that you weren't bothered by it?
Objection, foundation.
Okay. Did you say days afterwards that you weren't bothered by Hackamania?
I don't recall if I did or not.
Your Honor, I'd like to be able to share a screen if I could.
May.
All right, let's see here.
I mean, it was good news to me, but it was bad news for the rest of us. Los Federales, I'm flying to the Dominican next month, scored business
Go
class.
ahead, pause that, Mr. White.
Hang on a second.
Yep.
I'm sorry, this fired up before I could.
I understand. This is T50, I believe. We can see the first portion of it or the claim title of it. Mr. Johnson, have you reviewed this?
I am not, Your Honor. I believe opposing counsel is submitting this for impeachment purposes. It looks like the video is 4 minutes and 16, 4 hours, excuse me, 4 hours and 16 minutes long. And I've not been given any indication on what opposing counsel plans on showing in this video.
Well, Your Honor, Mr. Johnson is correct. I'm submitting this for impeachment purposes. I shared this with Mr. Johnson when we were having a break. Mr. Imholt has just testified as to something, and I believe that you'll find that that this video will do if not the exact opposite, will give clarity to the court as to what Mr. Imholt did say days after the Hackamania event.
All right. So your question at this point of Mr. Imholt?
My question to Mr. Imholt was, do you remember saying that Hackamania didn't bother you, the events of Hackamania didn't bother you days after the event?
I remember people trolling me on my program and saying that the trolling didn't bother me as part of my performance on my program, while behind the scenes, I was already in contact with people in my real life to try and remedy this situation. Who I am on my program is a performance, it's a comedy show, versus what I'm doing behind the scenes in my real life that is not online, that I'd rather not discuss publicly on my program, are two different things. When I say that trolling or anything like that doesn't bother me on my program, that is typically designed to misdirect any further trolling or get people to stop engaging in a certain type of behavior. But in my real life, this is a far different story.
So, but wasn't Hackamania an online event?
Once they disseminated photos of me without my permission, I believe that broke through that wall. It is not performance to disseminate photos and messages of someone without their permission. That is not a performance, sir.
Huh? In your opinion?
Yep, we got it.
Okay. Mr. Imholt, aren't you holding Mr. Rekieta to a standard that is different than your own? You just testified that your show is not connected to your real life, but somebody saying something on a show or appearing on a show is connected to your real life?
Specifically, the dissemination of images and private messages. If a show wants to criticize my program or my public statements or anything like that, that is different than disseminating private images against someone's consent.
Private images. And who took those images?
I do not know who took those images. I do not know how those images were acquired.
Okay. Do you know for a fact that it was Mr. Rekieta that pushed publish on those images?
Your Honor, we already had this this line of questioning.
No, you didn't.
Excuse me.
Go ahead, Mr. Johnson, with your objection.
Your Honor, we already had this line of questioning when Mr. White was asking my client about his ex-wife or anybody else having access to this information or releasing his private information. We did discuss this already.
No.
Generally, just maybe to help the parties out so we don't go back and forth over the same thing, and Mr. White gives his semi-closing argument and Mr. Imholt gives his closing argument in response over and over. Perhaps we could focus on the fact that the court understands that other people may have access to other things and may be involved in any dissemination that's involved. That may not be entirely helpful to the defense in this case, but I'll take that argument when it comes. That argument sounds like a good time for closings or briefing, and we can move forward. We are running up against time. Mr. White, if you would ask complete your cross. Ultimately, I'm anticipating some rebuttal testimony, so there may be cross about that rebuttal testimony later, but if you would complete your cross, thank you.
Yes, Your Honor. May I have a moment?
We have 4 minutes, but yes.
Thank you. Mr. Imholt?
Yep.
You testified earlier that you had some concerns about Mr. Rekieta commenting on your genitalia. Why did you discuss or show your genitalia to Mr. Rekieta?
I don't.
Objection, relevance?
They brought it up, Your Honor.
Sure, but they brought it up in the context that he didn't want to disseminate it.
I understand.
Do you have
I
a question?
understand that.
All right, I'll ask the only question that might be relevant. Mr. Imholt, was there ever any time where you during communications with Mr. Rekieta or anyone else involved in the complicated relationship you testified earlier, did you ever discuss disseminating information about your genitalia to other people outside that complicated relationship?
No, never.
Okay. Mr. White, do you have any other thing to impeach him on at that said he saw
No,
his
Your Honor.
genitalia once? Okay.
No.
Thank you.
Mr. Imholt, have you yourself ever disseminated a private image of someone else on your show?
Objection, relevance.
Your Honor, Mr. Imholt is asking to be able to have it both ways. He wants
All
to
right.
be able
He can
to
answer that question overruled on your show.
Your Honor, there's a pending criminal matter. I think that my client would not be serving himself by answering that question.
And that's not post-sentencing.
It's not post-sentencing. Sentencing has yet to occur.
Your Honor, then the Mr. Imholt can take the Fifth Amendment, rely on his Fifth Amendment privilege, and the court can take a negative inference.
Your Honor, I'm going to object to this line of questioning. My client's behavior is not at issue here. What is at issue here is Mr. Rekieta's conduct towards my client, which is why my client filed the harassment restraining order. It's my belief that opposing counsel is trying to get this information to embarrass my client and negatively impact his pending criminal case. That is
Mr. Johnson. So we're going to cut off for today. What I'm going to do is I'm going to ask the parties to consider the following stipulation pending the continued hearing. And that stipulation is going to be Mr. Imholt was charged with an allegation of dissemination, and that dissemination involved something on his public show. He is not making an admission to that. It just gives it in context. I don't know that unless it's somehow tied to an agreement to allow others to do that defeats plaintiff's argument on whether or not Mr. Rekieta could do it. So if you can consider that, we do have to close the hearing for today. We are going to continue the hearing. I'm going to reach out for the attorneys. We're going to end up on my calendar. It's probably going to be set out for a significant amount of time. I'm going to set a informal scheduling conference with the attorneys on this and Mr. Melton's case as well. We're just going to reach out. My primary clerk is today. I've got to take this off Master Family because it's just got to get off there. And I'm going to block out a date to continue this hearing. I'm also going to continue the hearing in 7-3 CV 255504, which I'm calling right now and continuing in that case. For the record, that hearing was scheduled at 11 o'clock. Both plaintiff's attorney as well as Mr. Melton's attorney are the same plaintiff and respondent attorneys in file 255379, Mr. Imholt versus Mr. Rekieta. We started at 10 o'clock. We are now at 1 o'clock, and we have numerous other hearings that were otherwise scheduled. I will be continuing both hearings, likely to a morning and afternoon separate block, and I will set a hearing to discuss to make sure that the evidence in both of those files has been gone over before, and that everybody has admissible evidence, so we don't spend much of our time working on whether something's been disclosed or not. And also if the parties have any ideas on how to not repeat this exact hearing or large chunks of it again for Mr. Melton, given that they're both are the same. It's the same evidence and the same arguments. I'm not binding you guys to do that, but I think there might be a way we can do it. And we'll discuss that with the attorneys and see if we can come to some agreement and stipulation. At this time, the hearings are adjourned, and I will reach out to discuss next steps to both the attorneys. Thank you, everyone, for your patience today. Mr. Johnson or Mr. White, anything additional today?
Yes,
Yes,
Your Honor.
Mr.
Sorry.
White, go ahead.
I would like 5379 to proceed, if possible, in person. 5504, Mr. Melton's case, is difficult because he's in Las Vegas, Nevada. But Mr. Ricada is in Spicer, and I am more than willing to travel to Stearns County in order to appear in person, because I think this would have been more effective had we been in person.
And I understand the technology makes it not as clear. I also note in the chat room, I'm kicking someone else out now too, who decided that it was a good idea that BBC World wanted to give us a shout out to their page. And I do have some concerns based on the testimony here about, given this is an HRO hearing, they're both HRO hearings, about the protection of parties for an in-person hearing, noting that there were a large number of people at Mr. Imholtz's criminal cases. So I'm going to take that. I'm not even taking it under advisement. I'm going to discuss that with attorneys offline. I'm noting for the record, because I think it's important, numerous people, and again, I don't know who they are, supporters of, observers, general members of the public, but they aren't here just to observe. They're also chatting and adding things, and I can't have that in person. So I've got to take that into consideration. I understand your point, Mr. White, and let's see if we can do something together. Thank you all.
Your Honor,
Mr. Johnson, sorry, go ahead.
you're fine. Thank you. I don't know if the court would be willing to consider a temporary restrainment for the parties not to discuss the case at hand pending the outcome of the matter.
Mr. White, do you agree witnesses are sequestered? So I think that order, itself requires that anybody who could be a potential witness. So obviously, Mr. Ketta, Mr. Melton, Mr. Imholt can't be talking about the case. Do you have any objection to your client and Mr. Johnson's your clients and Mr. Johnson not discussing the facts related to this case?
Just a moment, Your Honor.
Thank you.
And again, it'd be limited to the principal parties.
Yep.
I'm not exactly sure how broad this would be. What exactly is Mr. Johnson asking for as far as the breadth of this is concerned?
That there be no social media posts or YouTube discussions regarding this matter pending the outcome.
Yeah, but how far is regarding this matter is the question I'm asking. Are we talking about what testimony has been offered? What evidence has it been admitted? What are we talking about here? I need to know.
Excuse me, it's an all-inclusive request for everything that's been discussed today, all the evidence that has been provided, submitted, everything as a whole, that it not be discussed by the parties in any format whatsoever.
I think my client has been kicked off.
Yep, he is using a thing that we have determined is recording. So if he would like to be put back in, he needs to stop that.
All right, so that's my clerk talking about someone's client recording. I am going to put an order together. If the parties want to give me proposed orders, the oral order for now is you have to wait till Tuesday till I review any proposed orders. But for now, and until I find something else, no party to this hearing shall talk about anything that's happened on this hearing unless they're required in some other court hearing or with their attorneys. So no public posts, no social media, no discussion otherwise. Obviously, they can't control what followers or other individuals that are just general members of the public post. That's up to them. But obviously, I also don't want either party creating more evidence for the other party. We've already got a lot of exhibits. So
All right.
that's where it is now. Obviously, if we want to tailor that, the best case scenario would be the attorneys working together on that and
Right.
putting a joint proposed order. Thank you both.
Right. Thank you.
Thank you, Your Honor. Thank you for your
Yep.
patience. Have a good day.